Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Evidence may be direct or circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is proof of one or more facts from which you could find another fact. You should consider both kinds of evidence. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It is for you to decide how much weight to give to any evidence. There are rules of evidence that control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence and a lawyer on the other side thinks that it is not permitted by the rules of evidence, that lawyer may object. If I overrule the objection, the question may be answered or the exhibit received. If I sustain the objection, the question cannot be answered and the exhibit cannot be received. Whenever I sustain an objection to a question, you must ignore the question and must not guess what the answer might have been. Sometimes I may order that evidence be stricken from the record and that you disregard or ignore the evidence. That means that when you are deciding the case, you must not consider the evidence that I told you to disregard. In deciding the facts in this case, you may have to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, or part of it, or none of it. Proof of a fact does not necessarily depend on the number of witnesses who testify about it. In considering the testimony of any witness, you may take into account 1. The opportunity and ability of the witness to see or hear or know the thing testified to. 2. The witness's memory. 3. The witness's manner while testifying. 4. The witness's interest in the outcome of the case and any bias or prejudice. 5. Whether other evidence contradicted the witness's testimony. 6. The reasonableness of the witness's testimony in light of all the evidence. And 7. Any other factors that bear on believability. Sometimes a witness may say something that is not consistent with something else he or she said. Sometimes different witnesses will give different versions of what happened. People often forget things or make mistakes in what they remember. Also, two people may see the same event but remember it differently. You may consider these differences, but do not decide that testimony is untrue just because it differs from other testimony. However, if you decide that a witness has deliberately testified untruthfully about something important, you may choose not to believe anything that witness said. On the other hand, if you think the witness testified untruthfully about some things but told the truth about others, you may accept the part you think is true and ignore the rest. The weight of the evidence as to a fact does not necessarily depend on the number of witnesses who testify about it. I will now say a few words about your conduct as jurors. First, keep an open mind throughout the trial and do not decide what the verdict should be until you and your fellow jurors have completed your deliberations at the end of the case. Second, because you must decide this case based only on the evidence received in the case and on my instructions as to the law that applies. You must not be exposed to any other information about the case or to the issues it involves during the course of your jury duty. Thus, until the end of the case, or unless I tell you otherwise, do not communicate with anyone in any way, and do not let anyone else communicate with you in any way about the merits of the case or anything to do with it. This includes discussing the case in person, in writing, by phone or electronic means, via email, text messaging, or any internet chat room, blog, website, or other feature. This applies to communicating with your fellow jurors until I give you the case for deliberation, and it applies to communicating with everyone else, including your family members, your employer, the media or press, and the people involved in the trial. Although you may notify your family and your employer that you have been seated as a juror in the case. But if you are asked or approached in any way about your jury service or anything about this case, you must respond that you have been ordered not to discuss the matter and to report the contact to the court. Because you will receive all the evidence and legal instruction you properly may consider to return a verdict, do not read, watch, or listen to any news or media accounts or commentary about the case or anything to do with it. Do not do any research, such as consulting dictionaries, searching the internet, or using other reference materials, and do not make any investigation or in any other way try to learn about the case on your own. The law requires these restrictions to ensure the parties have a fair trial based on the same evidence that each party has had an opportunity to address. A juror who violates these instructions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. If any juror is exposed to any outside information, please notify the court immediately. During deliberations, you will have to make your decision based on what you recall of the evidence. You will not have a transcript of the trial. I urge you to pay close attention to the testimony as it is given. If at any time you cannot hear or see the testimony, evidence, questions, or arguments, let me know so that I can correct the problem. If you wish, you may take notes to help you remember the evidence. If you do take notes, please keep them to yourself until you and your fellow jurors go to the jury room to decide the case. Do not let note-taking distract you. When you leave, your notes should be left in the courtroom. No one will read your notes. They will be destroyed at the conclusion of the case. Whether or not you take your notes, you should rely on your own memory of the evidence. Notes are only to assist your memory. You should not be overly influenced by your notes or those of your fellow jurors. right, next let's try some literary material. This is called Preparing for Rainy Days. 4 ways to help make your roof leak-proof. Ready? Here we go. Considering the record-breaking heat last summer, we understand why you might welcome the storms El Nino is sending our way. But before you start planning to spend your weekends curled up on the couch with a cup of tea, watching the rain pitter-patter on your windows, take some time to prepare your home, and in particular your roof, for the storm. Of course, roof maintenance is important all the time, but this year it's especially critical. Experts say that homes could be more susceptible to leaks this spring because the summer's high, dry heat caused the wood in houses to contract and open up small gaps big enough to allow water to leak through. And that's why homeowners should make sure their roofs are sealed up tight before the rains come. Following are some steps to take to help you avoid leaks this spring. Perform a thorough inspection. You should give your roof a good once-over, at least annually, and twice a year if possible. It's not as difficult as you might think. Just put a ladder up to the side of your house and check for missing or worn shingles. Take a particularly close look at spots where there's flashing or where 2 different materials meet, such as the areas around chimneys, vents, and skylights. If they're not sealed right, they're prime spots for leaks. Homeowners with tile roofs might think they can skip this step, but they shouldn't. Tiles can slip, chip, and crack, exposing the felt paper underneath to sun, which in turn causes wear and tear to the paper, leading to possible leaks. Hire a professional if necessary. If you're not comfortable looking at the roof yourself, or if you think you found some trouble spots during your once-over, call a reputable roofer and make an appointment for a general roof inspection. The best person to hire is the contractor who installed your roof because of his or her familiarity with your house. All right, we'll get back to that. But next, let's try this closing argument. Ready? Here we go. All murders are killings of malice. Once you know what malice is as defined by the law, you'll know what a murder is. Number 2, all murders are second-degree murder unless there's special facts that make them first-degree murder. So the easiest way to look at this is first determine, do we have a killing with malice, which would be second-degree murder. Then, if we do, see if we have facts that raise it to a first-degree murder. Now, to prove the defendant is guilty of murder, the people must prove that 1. The defendant committed an act that caused the death of another person. Yes, we've done that. 2. When the defendant acted, he had a state of mind called malice aforethought. 3. He killed without lawful excuse or justification. Now, there's 2 types of malice. There's express malice and implied malice. Proof of either one is enough to establish state of mind required for murder. Here's what express malice is. This is taken directly from the jury instructions. The defendant acted with express malice if he unlawfully intended to kill. Now that's the end of the jury instruction part of it. Here it's kind of, we prove that because the proof's in the pudding. You cannot shoot a woman in the back without intending to kill. Plus, he had a financial motive to kill her. The proceeds of the house. He didn't have a financial motive to just wound her. That indicates quite clearly he shot her with the intent to kill. 3. The defendant acted with implied malice if 1. Strike that. There's 2 ways to get to malice. One is express malice, intent to kill. The other is what we call implied malice. Implied malice. 1. He intentionally committed an act, a shooting. 2. The natural consequence of the act was dangerous to human life. Obviously, they were. 3. At the time he acted, he knew his act was dangerous to human life, which obviously he did. And 4. He acted with conscious disregard for human life, which he certainly did. In other words, we don't have to prove the defendant specifically intended to kill, although clearly he did. All right, let's finish up our literary material about checking our roofs. Ready? Here we go. If that roofer isn't available or you don't know who installed the roof, ask friends for recommendations or inquire at the Better Business Bureau. Make sure the inspector is licensed, bonded, and in good standing with your state's contractor licensing board, and check customer references. Always ask the inspector to take photos so you can get a first-hand look at the trouble spots he suggests you fix. And if he says you need a new roof, get a second opinion. Perform basic roof maintenance now. Take time to clean out your rain gutters. And while you're at it, make sure they're securely fastened to your house so they can do their job, directing the water off your roof and house during a storm. In addition, clear out any debris buildup, such as leaves, from the valleys in your roof, which are also designed to carry rainwater off your roof. After a big storm, check your gutters and roof again to make sure there are no clogs. Remember, putting off maintenance can void the warranty on your current roof. So, by all means, if you know of any leaks in your roof, take care of them now. This is not the year to defer repairs. Don't forget about your trees. During the heat wave last year, many trees got so dehydrated that their roots came to the surface looking for water. That makes them weaker than usual. Heavy rains and high winds will pull them out of the ground more easily than usual this spring. So if you have trees near your house that might uproot and fall on your roof, hire an arborist to assess their health. Also, trim back any tree limbs hanging over your home so they don't crack and punch a hole in your roof during a strong storm. All right, that will conclude our literary and jury charge practice.